What is discovery in the course of a divorce proceeding or any court proceeding for that matter? So discovery is the process of asking questions or asking for actual documents, files, or tangible evidence that relates to something that we're trying to prove or disprove in the course of your case. So let's say that there's an allegation that someone is having a substance abuse issue in the marriage that has impacted their ability to independently be with the kids safely. So they can't safely parent because we don't know if they're going to jump in the car with the kids. And we need to produce evidence of that. Your word that he's a raging alcoholic or she's a lush isn't enough. We've got to establish how we know that and proof of that. So discovery is exactly what it says it is. It's discovering the evidence. We're looking for papers, things, or information that is going to either provide relevant evidence or that could lead to the discovery of relevant evidence. So that's what we're looking for. The types of information that you collect during discovery are, first of all, there's written discovery. In family law, there is a rule that is unlike circuit court rules, or the rules of civil procedure in Florida, that says there are initial family law interrogatories that have to be served in each case, and they are very limited to certain topics. Then you have the opportunity to interrogate, ask 10 more questions without leave from the court in a family law case. However, if you are in a situation where you need some particular types of discovery around electronically stored evidence, et cetera, or electronically stored information, data, computer files, et cetera, and you've got to go on a hunt for that, you're first going to need to know, well, what are those devices and where would these things live? Therefore, you might need to ask the court to give you the opportunity, you move the court for the opportunity to ask more than the 10 questions that you're limited to in family law. Those cases are few and far between. The other type of written discovery is a request for production of documents and tangible evidence. So this is, we shorthanded it calling it an RFP. But what we're doing is we're saying, hey, we think that you have the following documents. You have emails showing you had an affair and it violates the terms of the premarital agreement or the postnuptial agreement. So we're looking for evidence of some kind. So we're asking for any and all emails that are relevant to this. Or we are looking for any and all computer files that are related to the thing that we're trying to prove or disprove. That is a request for production, meaning somebody's got to give it to you. And you've got 30 days each time a written request for discovery, either written interrogatories or a written request for production are provided to you. With respect to written discovery requests, when your lawyer receives them on your behalf, or if you aren't represented and you receive these yourself, you do have 30 days to respond. If something seems ambiguous, like you don't even understand this question, it's so broad that it would take 10 years to put all the information together and provide them what they're asking for, then there are grounds to object to this. So this is what you do. You write, objection to the question, objection to the request for the following reason. And the reason needs to be specific to your circumstances and the question that is being posed or the request that is being made. Do not use just generic objections. They will be overruled by the court if we have a motion to compel. The other thing is you may not want to answer some questions because they seem invasive. Unfortunately, in family law, we're already in invasive land. The requests for financial documents are invasive. Unfortunately, this whole period of time is going to feel like you're exposed. You're not. It's going to be over sometime, but as far as invasive, if there is some truly confidential information that should be protected by attorney-client privilege, accountant-client privilege, etc., then we can certainly object on those grounds to those requests. However, there will also be an opportunity to say, hey, we know that this is privileged, but we're entitled to it because. And then we have to have a hearing before the judge, present our position supported by case law, and then the judge will rule on that matter. Another type of discovery is the deposition. We've heard of this. This is where you're in a room with a witness and there's a court reporter present. There is no judge, and each party's counsel is there. The parties can both be there as well if it's a third-party witness or if it's one of the parties. So this is where somebody, the lawyer, asks the witness questions that are relevant to the allegations in the petition and or the counter petition that's at issue in your case. In family law cases, unlike complex business law cases, discovery is a tool that we need to use sparingly and strategically to get information that we need to establish things like, well, what really is in the best interest of the children? Is there something that the spouse is engaged in that is putting our children at risk? And if so, how do we establish that? We look at these things when we think that someone is indeed hiding assets, and we need to ask questions and ask for particular documents or things in order to establish that so that we can present that evidence to the court. If we are in a situation where there is a real legal or factual question that needs to be presented to the court at some point, either at a hearing, on a motion, or at trial, and we're going to have evidence of that, we need to leverage the discovery rules and tools in order to get to that. Otherwise, it's he said, she said, and the court doesn't care. If you have questions about discovery issues in divorce and how they play into your case, feel free to give Brava Family Law a call and set up a consult.